Well, good afternoon out there. Welcome to the Bold Inventor Show. I'm your host, JD Houvener, with Matt Kulseth. Matt, good day to you.
Hey, how's it going, everyone? JD, good to see you.
Yeah, good to see you too. Happy to be on. It's our summer edition. We're casual for those podcast listeners. Not like you would know or care necessarily, but Matt,
how's your casual Wednesday around here?
Casual Wednesday. We were talking before we went live. Your kids are on at camp. You're off.
Yeah, so I got two girls. They're both off at camp for the next 2 weeks, overnight camp. So
nice.
We got the house to ourselves. Got a lot of projects to get done. Yeah.
Nice. So, good husband wife time. Yeah.
Yeah, it'll be fun. We went out to a movie last night. We haven't done that in, who knows how long. So
okay, I'm gonna have to take notes. Yeah, we haven't done that. Our kids. Maybe they're about the same age. I don't know. 10, 9, and 7.
Yeah, our kids are right in there. They're 9 and 12, basically.
Cool.
Yeah.
Well, good. Yeah, I'm looking to kick off my flag football season here. It's our first year on the NFL flag, all branded here in Moses Lake. So I'm excited to get that going. A lot of good old boys.
You look like you're ready to go.
Yeah, we have so it's girls mostly because a lot of the guys just want to play kind of old school. They want to tackle, but we're going to kick it off with the girls, 3rd grade and up. We have 50 signups. It's good for our first year.
That's amazing. That's a lot.
It's a smaller town. Exactly. We're gonna try to get 3 or 4, probably 4 teams. Just do 5-on-5, have some fun. And hey, Jonathan, good to see you. Happy you made it on. We're doing Q&A today, all hour. Jonathan.
Love it.
For those that may be new to our podcast, new to our video. We are attorneys. I'm a patent attorney. Matt is a trademark attorney, and we work with Bold Patents. I own Bold Patents. We have been doing that for many, many years, and we'll be doing some Q&A on preloaded questions that have come in through Reddit, through our Facebook, LinkedIn, as well as our, where else? Amira does an incredible job polling questions.
We're everywhere.
We're everywhere.
We're everywhere. Except we're not on the dark web.
No. Well, we probably are. We don't know we are, but I've been there.
We wouldn't know.
Hey, what do we know? I've never been there, Matt. Have you been there? What are you talking? What are you saying?
I'm afraid to even Google what is the dark web and how do I access it. Right?
As well. Yeah, you have ChatGPT. It'll tell you.
Well, I don't need to be on anyone's list anywhere. So no,
I don't want to know. Right on. That's awesome. So we could dig into it. We don't have any guests today, but I just want to highlight again: if you're coming on, you're live right now. You have got the opportunity of a lifetime to ask a question, get to the front of the line, and we'll skip I've got probably 30 questions, Matt. We're just going to chop through, maybe take a break, stretch, get some water, and get into it. So let's do it.
Let me stretch.
Yeah, get a good stretch your brain, and it'll be good for your body too. You're talking about going to the gym later, so let's get into it. So
I'm ready.
Let's do it. And we do run the risk of some of these questions having been asked before. So let me know if one sounds too familiar. And
I'll answer it differently.
We could even do like the Matt and JD versus ChatGPT. See what
that's actually kind of fun.
You want to try that? Just like, anyway.
Kinda.
All right.
I mean, I guess maybe. Well, we could talk about it sidebar and.
Let's see what comes back. I'll basically have a little short. I'll force it to do a short answer. Okay, first one here, and again, I have 0 prep. What should I be prepared to provide a patent illustrator? Drawings, description, things that might look similar, CAD files. Good question. I would say it does depend if you're on your own. If you're filing a patent on your own, you're going to want to give them as much as possible. I think tell them exactly what you've done. If you're writing an application, giving them the whole spec or maybe a nice abstract that talks about what you want to claim. If you're at the non-provisional phase, claims are what will control what you own. And so if you've got those written out, your patent illustrator will want to make sure that you have in your spec what's called the detailed description of drawings. You're going to want to have, of course, all the details there, all the flag notes and references back. But we want to make sure that what is in the drawing supports the claims. So you have to have everything that's shown. Drawings are kind of in the nice to have bucket, honestly, Matt. If you know, there's drawings as required. Yeah.
In my experience too, like they're not that expensive to get done.
No, and but you can pay a lot. I mean, especially when it comes to design patent drawings, you're going to want to show a lot more shading and all the 3 dimensions in the design patent side because that's what you own is the drawing.
Yeah.
So a lot more effort on the drawings there. So yeah, and then if you're working with an attorney, put the heavy lifting on your attorney. They're going to be the one that should be, at least the way Bold works, be your intermediary, your representative to help make sure that Illustrator gets everything right, because your patent attorney is the one drafting the application. So
yeah, they're going to have to deal with it.
yeah, exactly. Let's, just out of curiosity, let's do a good old chat. Give me a 100-word answer. This could get boring.
Yeah, for some context, I recently had some trade dress drawings done by one of the groups that we use at the firm. And yeah, I think they're about $80 each, something like that. They're really affordable.
Okay.
It's a pretty in-depth renderings too. I mean, they were generated from a photograph, right? So I imagine it's a lot simpler than you might think it is, but they're pretty good.
On that note, you nailed it. ChatGPT, first thing it said is, hey, be prepared to provide your Illustrator with clear written description, 1 point for JD, highlighting key features and how it works. But also, I missed this, give them photos, rough sketches, send them existing prototypes to convey the structure and function. That's right on. If a similar product or patent exists, provide those references as well. So if you know of other patents that have been issued on the same or similar subject matter, why not use and lean on kind of someone else that's gone through the patent process, gone through examination. So I like that suggestion as well. So thank you, Chad. Cool. Well, let's go to our next question. Unless we have any live ones. I don't see any. Matt, you ready?
Yeah, dude, let's do this. Man. I'm having fun. This is great.
Good. All right. Yeah, you could be bench pressing or squatting right now.
It's arm day.
Nice. All right. This is a lengthy one. I'll try to read off for our podcast listeners. I'm in the process of filing a trademark. I was asked to amend my description of my logo, as well as update my class descriptions. Inside the amend response form, I see the option to upload the specimen as well to the website the mark is on. Do I need to input this information again if I did the initial application? The reason I'm asking is that I want to go to the end of my response to download the PDF. I see a quote, no response in those rows. Pretty detailed question here. Any help?
Yeah, really good question. Yeah, so this is pretty straightforward. So like two parts to it. One, well, I guess one amendment, but two parts to the amendment. The first is for the description of the logo. One thing that I've been doing in the last few months that's worked out incredibly well is using ChatGPT to generate the description of the logo for the USPTO. It does it beautifully, like perfectly. I've had no pushback from the USPTO when I use ChatGPT to describe the logo to them. So that's what I've been using. So that's my recommendation for new applications. Generally speaking, the examining attorney is going to offer some really helpful feedback on how you describe that logo. So I would just go with what they suggest. That's pretty, it's generally the best practice. And then with regard to amending the, let's see, in the classes, upload the specimen. So they need a substitute specimen, it sounds like.
Okay.
Yeah, so you'll provide the substitute specimen. You do not need to provide, let's see, hold on one second here. Yeah, you don't need to refile the specimen. Actually, I'm sorry, JD, I'm having a hard time reading this.
No problem. No, here, let me get this over. There we go.
Yeah, there we go. Perfect. Update my class. Oh, update the class descriptions. Got it. Okay. Yep. So you can update the class descriptions in the amendment. You do not need to submit a substitute specimen as well, unless they're putting you in a different class. Then you might need to upload the specimen. But my suggestion here to this person would be to just email or call the examining attorney. He or she will get back to you pretty quick, and they'll tell you exactly what they want. And they might even offer to do it for you via examiner's amendment if it's minor.
Got it. And if all this seems like it's too much, of course, you could just pick up a phone and call Bold.
Yeah, you can call me.
Matt would take care of it for you.
Of course.
I think you nailed it. ChatGPT, it had a few things in here. I think I missed actually a lot of what you said. It mentioned if there's an amendment response to a trademark app, you must re-enter or re-upload information if prompted. If your downloaded response PDF says no response, that means nothing was submitted for those fields, which could be an office action. Is that right?
Potentially. Depends on if that information was submitted prior.
Okay.
So in the first application, you submitted it, and the second one you didn't, but you're not relying on it. It depends.
Okay, so you can get in trouble pretty quick because you can't really rely on what you submitted before.
Yeah.
Each submittal kind of stands on its own.
Yeah. If I was putting it into a different class, I would probably re-upload that same specimen. Again, just because but worst case, the examining attorney is going to issue another office action, and you'll have another 3 months to fix it again. So
I'm learning a bunch here. It's good stuff.
Basically, everything can be fixed at the USPTO if you do it in a timely fashion.
Okay. All right, moving right along. We're just moving through, heading back to the patent side. Grab a glass of water, Matt.
I got it.
All right. Hi. A patent for an electronic device that has a long expired claim. Claimed the use of a short and long electrical pulse to perform a specific function. A recent patent also claimed a short and a long pulse to perform the same function, but the claim differed by stating the use of a long pulse and the same short pulse, but one with a specific time of 5 microseconds or less. I'm no expert, but it seems to me that the older patent did not need to claim any pulse times, and its claim should have caused the new patent claim to be rejected. My question is this: should the claim in the second patent that only added the short pulse time have been granted? Would the assignee of the new patent still have a valid complaint based on the existence of the old patent if the method were copied? Okay, good question. Fairly detailed. Gosh, I would say, so there's an old, basically it sounds like an expired patent that's talking about, hey, long pulse and a short pulse. Generic, they were the first, they were the grandfathers, so they sort of had that nice broad protection, broad rights, exclusionary rights. And a second patent came in and was issued, with a much narrower scope regarding the second one being specifically 5 milliseconds, I think it was, or less.
Yeah, something like that.
Very short amount of time. So a couple of things. You would have to really answer this, you'd have to look at what's called the prosecution history. Go see if the examiner, and this is public information, inside public, it's not called the patent center. Go see what happened. Did the examiner cite that expired patent that you're talking about? It's likely they did, and you hope they did if it's that so close. And there was probably some back and forth. And my guess would be that the patent owner, and maybe if they had an attorney, was able to successfully argue that there was it was not an obvious amount. There's something where a pulse, the second pulse was in industry or common to be much longer, and nobody's doing 5 milliseconds or less, or isn't even achievable, right? And so somehow producing evidence that it was not an obvious way of administering a second pulse. That's kind of all I got.
Yeah, I'm wondering maybe if the application's completely different, right? Same technology but different use case, right? And they're using it in a different way for a different purpose, but they might be using similar technology. I suppose that could potentially.
I think so. Yeah, right. Yeah, like one's for laser hair removal, one is for a sensor, for detecting, image detection.
Sure.
Right. And so, great, Matt. I think that's probably right. Good point.
That's the only way I'm thinking about it is like maybe there's some use case here that's not lining up exactly, right?
That's what the chat's got. Gosh, look at chat go crazy here. Here's the summary. I'm going to read the summary. The newer claim might be valid, but only if the 5 microsecond limitation adds something non-obvious. Yes. The assignee of the new patent cannot stop someone from practicing what was already disclosed in the old patent. If the claims cover methods fully disclosed earlier, they may be vulnerable to invalidity arguments. Look at that. Yep. Well, I like your answer too, Matt. But I'm super happy that they came back and mentioned non-obviousness. And it was sort of on the assumption that we're talking same technology. Different technology, there may not be that obviousness requirement. Say we're talking about different apples and oranges.
Mm-hmm.
Great question. That was fun.
That was good.
Cool. All right. Again, anyone out there listening live, this is your chance to ask. Patents, trademarks, copyrights, trade secrets, anything goes. We'll
Marriage
do
advice.
marriage advice. We're both still married.
Still
10
married.
plus years. We hit our 15th. Are you close?
We're 16 this year. 16,
Oh, that's great.
16 in 2 weeks.
Congrats. That's awesome.
Yeah.
Good.
It's been a good run.
That's really good. All right. Yeah. All right. And I have my air conditioning turned off just to make sure I have the right power. So I'm starting to sweat. I'm passing the microphone over to you on this one, Matt.
We'll take care of that in post-op.
Yeah, yeah. We'll pause it and I gotta wipe my brow. Okay. No, we just did that one. Here we go. Hi, I'm looking to start an educational company that provides educational services. That's good. I have a name that has been used for 9 years or so. It has not been registered. They say trademark, but not registered. And I'm looking to trademark it.
Great.
However, my search revealed that a trademark was filed for a company that I can find zero info on outside of the trademark search that sells custom products in the industry. What? Would an educational service company be seen as different enough to warrant a separate trademark? Or would it just be easier to rebrand?
Yeah, good question. Without more information, it's really hard to make to say yes or no definitively one way or the other. But I would say, if you have 9 years of use, there's a good chance that this third-party company that has a trademark registration for some product affiliated with education services is a junior user, right? You've probably been around longer than they have. So you'd want to go see, their proof of use, make sure that their trademark is valid. Might be a Chinese company. A lot of their trademarks are not valid in the United States based on their application practices. But you want to go take a look and see if you have better rights. And if you have better rights, then no need to rebrand. Talk to a trademark attorney and see about, either approaching them, asking for a consent agreement, or filing a cancellation if they haven't already filed a Section 15 incontestability document. So yeah, lots of options. But I think the first thing to do is just talk to someone who can give you the yes or no answer. And in this type of thing, I think an attorney should be able to look at this pretty quickly if they know what they're doing and give you a yes or no what to do.
That sounds good. Yeah. And you mentioned that, better rights.
Yeah, better rights. So first in time, first in right in the United States, meaning, first in time to go to market is the person who presumably has senior user rights in the United States. Kind of different than patents in some ways, but first in time, first in right, meaning who goes to market first gets the trademark.
Right.
If you file the trademark before the other user, who might be a senior user, their application is junior to yours at the USPTO, but their rights are senior, meaning that they're going to have to challenge your first applied for trademark first.
Okay. So in this case, that could be what happened. Upon analysis, the person asking the question, the 9 years in some likelihood may have the common law right, but be the junior rights holder.
Have the junior trademark at the USPTO, but have the senior rights.
The senior rights. Very good.
So yeah, I think once those two questions are answered, you kind of have an idea of what to do next. So.
Well, that sounds good. Well, I'm going to do a quick plug. If you do have a question, you want to chat with us and look for legal advice, visit that link there and help yourself to a free discovery call. For taking action, using that link, we'll give you a copy of Bold Ideas, The Inventor's Guide to Patents. That's the book right behind me. Second edition. I'm working on a new edition, Matt. It's I'm going to reveal the title, which is Bold Ideas.
Oh, nice.
AI, obviously, and then with little parens, I think. I haven't got the cover design done, but there's AI in a lot of what we're doing these days.
Oh my gosh. I bet a quarter of what I'm doing right now as a trademark attorney deals with AI in some fashion.
Yeah. Not only the subject matter of our inventions, but the processes and how we as a firm are using AI to conduct searching, analysis, beginning to look into drafting as well. And it's just all over. And it's one of these things that's just growing so quickly in terms of how fast it can learn. When you start teaching and modeling.
Yeah, it's really interesting. Like In terms of like the practice of, being an attorney with AI, one thing I've noticed is a lot more clients using AI in their communications with us as attorneys.
Oh, okay.
That can be disorienting because
Yeah.
a lot of times, well, I can think of a few folks that I'm currently working with that use AI in their responses, and it can be really hard to navigate that because most of it is just fluff, right? It's just filler. It's just
Yeah.
kind of
Oh,
incoherent text that kind of makes sense, but doesn't quite fit right?
it's like you want to get on the phone. Hey, what are you saying here? Like,
Yeah.
what's the heart of your
Yeah.
concern? Yeah,
What did
that's
you mean by those 3 paragraphs where you said no? You know?
gosh. I haven't had, I'm not doing direct client work, these days. But I can speak to what Troy and you guys are going through at consults. Troy Schmelzer is our consulting attorney, and he said he's getting quite a few inventors that have invention disclosures. And he says, well, could you just explain this for me in your own words? And they just stumble,
Yeah.
because, maybe they weren't the inventor.
Right.
And AI came up with what they're saying is theirs. And it's interesting. I know we're not alone, but some of these, many of these, AI bots can piece together things from different industries, different applications, and I believe invent,
Yeah.
kind of point it in the right direction. They can invent. So it's interesting. And of course, right now, as of today, you have to have a human inventor.
Mhm.
And maybe the ethical quandary is, how does a human that's claiming to be an inventor sign an oath saying that they are the inventor, knowing full well that maybe they really only kind of planted the seed and asked the question or prompted? Is that going to be sufficient? So it's really
Yeah. I'm kind of, I'll be
interesting.
curious to see, like, at some point, like, when these trademarks start getting challenged for, these types of, non-human generated invention, or
Yeah,
disclosures or whatever. I'm
yeah.
curious to see who the onus is going to be on to prove that it was technology or wasn't technology, or to what extent. I don't know. Have you heard of any recent cases that have come out about this? And
Um,
how the
no,
USP is dealing with it?
no, I haven't.
I haven't
Uh,
either.
I think we're all watching. Although I saw last week the USPTO announced it is adopting an AI tool set for its searching for their examiners to begin using AI in their research for
Great.
patent, non-patent literature. I think it's great.
Great.
Yeah, I mean,
About
it's
time.
one. Yep, about time. So saving them time, making things more efficient and quicker. I'm all thumbs up for.
Yeah,
Uh,
we need that. We need more efficiency, quickness at the USPTO because it is brutal out there.
yeah, yeah. Well, I do think we're waiting for the USPTO director to be named. Right now, we have an interim
We
director,
have an interim, I think, still.
and so I think once that happens, I think then some things could shift. Might see
Yeah,
some policy change. Uh,
but yeah.
so
Right
a
now,
simple question. This one came from, gosh, where this came from? Our Quora audience. So this short and simple, sweet question here. How and what website do I go to in order to obtain a patent for an idea? Love it. Very simple.
IP.com,
I can say what?
bullpants.com.
Bulletpatents.com. Just knock it out of the park. I could pick this one apart a little bit and be kind of a jerk, and I'll kind of lean that direction. You can't get a patent for an idea, okay? And that's what I talk about in my book. You can get a patent for an invention, and so it's one important distinction. I think it kind of leads into what we're talking about. A lot of sort of the everyday inventor now. I think it's a great thing. It's an awesome concept that, hey, everyone is an inventor, and you want to get out there and go file something. You want to have thought it through. Think it sounds simple, but make sure what
It's
you're
got to be practical, right? The practical arts, right?
yeah,
Not an idea is not practical.
right. You want to, and not only just an idea, but something that you actually want. It is something you're motivated to go take action on and implement and see it through. Not just an academic or theory concept or practice. We work with inventors at Bold that are actually going to have impact in the market, either through themselves or through licensing. And there's a plan. So if there's a business plan, a concept, a marketability, something more definitive with your idea, and you've thought it enough through, you can write it out or speak about it such that someone else could build it or you could build it. Now you've got an invention. Okay, now from there's a lot of different places to go. One, you can do it yourself, but that can be most fraught, especially if you're not one to go through and want to learn and spend a lot of time and go through this kind of iterative process, which could be painful. So I don't recommend going it alone. But I do think you can start by learning about what is in the law and learning about what kind of an attorney you want to hire or a patent agent. So patent agents did not go to law school, but they passed the patent bar, and they do represent inventors quite well. And they tend to be more technology focused because they're really not trained in the law. Hiring a patent attorney will give you kind of that more holistic approach, covering both infringement, litigation, pre-litigation support, as well as some insight on case law. And you will pay more hiring a patent attorney. That's what we have here at Bold Patents. A lot of different places to go, lots of different law firms. So call around, make sure that it's the right law firm attorney that you're going to be able to work with. Make sure it's someone you can trust, and learn their style. It's not always about price. Not always about making a decision on based on cost. It's what's going to work best for you.
Good answer.
All right. I don't think I'm gonna pass on asking ChatGPT. Although, just in case it says bold patents, let's do it. How and what website? Here it is. To obtain a patent for an idea in the US, you must go to Bold IP. No, you need to file an application.
How long is it going to be until we're doing like Google AdWords for Google search results that pop up in AI, right? Gemini or whatever.
Oh my gosh! Right.
I'm sure it's already happening.
It may be, exactly. Yeah, I want to pay. You're now paying ChatGPT. Oh gosh. It says something that I actually didn't say, which is super important. In order to get a patent for an invention, you have to file an application with the USPTO. Should have said that. That is true. It must be filed with the USPTO. They really are pushing electronic. You have to pay extra to file a hard copy application these days.
Have you ever filed a hard copy?
I've never done it. You said you've done hard copy trademarks?
I had to in the past.
Yep.
For the electrical's out or whatever, right? And you got to go to the mailbox. Get it in the mailbox.
Such a relic, dude. You're like you're a dinosaur. I mean,
I know. I've only done it once. I faxed stuff in a bunch for the same reasons.
Yes. Hey.
But man, don't recommend it.
Gets the job done. Yeah, you found a part of a tree in.
Yeah.
Okay. Well, we're carrying on. How are we doing? About halfway through? Doing all right, Matt?
Oh yeah, great.
I'm good. All right. Well, another right. Anybody out there have questions? This is your time to ask away. We got another half hour left. We're heading over to Australia for this question.
Australians love trademarks.
I've noticed that. There's a lot of Australia stuff. IP.
Yep.
IP. I'm based in Aussie, in Australia. The trademark I'm after has been taken. The company trades in golf-specific clothing products. However, I would also trade in clothing products, not golf. The company's name is not affiliated with the trademark name. The trademark name isn't associated with any of the products at all. I only came across the company through an IP checker, which is a website, obviously. I would use the trademark name as part of my brand. Is it common for a company to register a trademark like Apple? Let's see if I can find the rest of this. What's my course of action? Thanks. I'll be correct. What's my course of action? Okay. I'll put that back up in case you need a reference.
Yeah, interesting. So let's just assume that he's asking about the United States, USPTO trademark process here in the United States, and that there's a company out there who's already registered for apparel, class 25 at the USPTO. And he has, so they're a golf company, it looks like, and he wants to do general apparel.
Yes.
Unfortunately, if there's a registration at the USPTO just for golf-specific apparel, it's going to block the whole class of products.
Okay.
So in this specific case, this individual is going to want to do some more research to figure out who this company is that owns the trademark. Are they actually using it? Did they ever use it? If they haven't been using it, how long haven't they been using it? And then you might, talk to an attorney about what's next. Can we respond to or can we put an application in with the plan to, cancel this trademark if we need to? But I think figure out a plan before you do anything. Yeah,
that's good. So you're not saying it's not totally dead in the water. When this person says, "Hey, it's been taken," that's not final. It's a
No, yeah, no. So, a lot of times I'll talk to clients in this situation who might have been using a trademark for 10 years and now they're, getting ready to sell in the next couple of years and they want a trademark registration. They think that's important, or someone's told them that's important,
Yep.
or the buyer wants it. That's part of the deal.
Yep.
So if that's the case, then yeah, we got to start taking a look at how we get this trademark through the process. So at that point, that's kind of when you come up with the plan, how you're going to approach this third party.
Perfect. That sounds good. And the Chat GPT, you nailed it. It's hitting it. Mentioning the same sort of thing here. It says key issues to consider: golf specific clothing. You want to use it for general clothing, not golf. Registered trademark doesn't seem to be used publicly or prominently in their products, and you're not sure if they're actively using it. You could conduct a full use and status analysis.
Mm-hmm.
File for a non-use removal application.
Mm-hmm.
This is in Australia, so it may not be related to.
Oh, yes. We would call that like a cancellation, non-use cancellation in the United States.
Yep. And then just like you said, consider negotiating.
Yep.
Evaluate the risk of infringement. Hey, that's always an option, perhaps, right?
Yep.
Rebrand, yeah.
Yeah, that's a lot of the times in this situation, if we have a senior user client and they have a trademark registration, we just approach them and just, be pretty nice about it.
Yep.
Like, hey, your client's got the registration. My client should own the registration. So how can we play together nicely?
Absolutely. All right, let's shift gears back to patents. These
Cool.
are amazingly ordered: patent, trademark. So we're doing good. This is about money here. A subject that's very important these days. I think a lot of us, certainly middle-class folks, are feeling the pinch. Prices are up. Feels like it's, it's just a little uncomfortable.
It's gotten expensive.
This person's asking, there is over 100% price difference for drafting the same patent. They all say it's high quality. I can't judge that, but how can they prove it? Do patent attorneys have some kind of statistic that can show inventors that it really is a good idea since they get the maximum out of my patent? How can a patent attorney prove that they draft really good patents? Ooh, it's so good. I think that's it. Goodness, calling us out. I do think you are going to get different prices, for what you're going to get. And I think if you just base your decision on, on an attorney or law firm based on price, then you're probably going to see some corners being cut. You're likely going to, for us, it's just, we kind of put our price out there. We do flat fee versus hourly. So that's maybe one thing to start with, is there's a difference between type of billing. And we've always done flat fee because I think it put myself in our entrepreneur or inventor shoes. We want predictability. And so before we start talking about the amount of money, the kind of money, I think is important to think about. So flat fee, you're going to know how much it costs, no matter how long it takes or how much effort or hours it takes the attorney. That can be refreshing, but the price itself can be jarring and high.
Yeah.
So for example, for us, for a provisional, our low complexity is $5,000. That's not an insignificant amount of money. I know there are places that will do it, as this person says, for half the amount, right? And it's a provisional application, so it's hard as an inventor to kind of know what's a quality work. And I think it's going to come down to interviewing. I mentioned that earlier in the show, getting to know the people, doing research on the attorneys, making sure they are who they say they are, looking at client testimonials, looking at work they've done before. At the USPTO, issued patents are public, and you can actually do a query on law firms to see, and that's part of what, if you go to the Patent Center and put in agent attorney and Bold IP, you'll see our 500-ish patents we've gotten issued. Take a look. And another way to think about overall quality from a kind of more technical, geeky attorney level is we haven't had any of our patents litigated, but that is, in my mind, the ultimate test. Is if a patent that we help, what's called prosecute, get a patent issued for, if it actually goes to a trial,
Yeah.
and if claims stand or if they are invalidated. That's kind of one of those issues. There's a lot more murkiness to it because laws can change. After patents is issued, laws can change, and all of a sudden that patent may not have as much legal footing as it would when it was just issued.
Yep.
Lots of other things to talk about in terms of quality. You can look at the claim itself and decide its breadth. And that is going to be subjective as all get out, depending on the industry. I mean, the most narrow patent could actually be very valuable in the right industry at the right time. But in general,
and like what we're talking about for the folks at home right now is just one little aspect of the patent,
right.
The tiniest aspect of it. And like folks litigate over this stuff for tens of millions of dollars.
Yes. So
It's
I don't
it's
have
all
an answer on this one. I mean, how about you? Maybe you could take this question on the trademark side. You probably this, lots of different variation in price.
Yeah, I mean, I think from my perspective, I mean, it's like a lot of things in at least my experience. You're buying the person. You're buying the service from them, but you're really buying the professional service or the professional that's providing the service. So yeah, I think if you want someone who's got experience, who's a specialist, who isn't just dabbling on the side in patents or trademarks. But yeah, pricing does tend to change quite a bit, from law firms to law firm, and depending on what product or service you want, right? So at our firm, we have a couple different options for clients. Sometimes we will suggest that the client just move forward with the application because we find no concerns when we do our knockout search, looking for obvious red flags. But a lot of clients are also going to choose to do a full search report and legal opinion. So if that's the case, then we'll prepare a search report and opinion for them. It just depends on client's budget too. But yeah, just in terms of picking your attorney, though, I think if you can get some references from other people in your industry, I think that's the best way to go.
Absolutely. Yeah, ChatGPT. This one came back, said some good stuff. Patent attorneys can demonstrate quality through several indicators, high grant rates, which is also kind of an asterisk because, hey, if you make it so narrow, you're going to get them all granted. Yep. Minimal office actions, strong claim strategies. You can show past patents with broad enforceable claims, share anonymized client success stories, such as licensing deals or litigation wins, and then technical expertise in your field and industry recognition, also signal quality, and ask to see sample patents they've drafted. So,
yeah, I think that'll make sense. I was thinking too when it was talking about like trade or patents granted. We kind of have the same thing on our side in terms of like looking at the applications that register. It's hard to quantify it though because not all clients go to market.
Right.
Trademark applications, right? So it's really hard to get a good sense for, the quality of your trademark or patent attorney based on those numbers.
Yep.
And everyone's gonna have a different strategy.
We might have lost you. I think the video froze up. Maybe it's on my end. There we go. I think we're good. We're back. Cool. See that last piece again?
Yeah, I think I would hire someone based on experience and then just the impression you get from them. Are they someone who's going to be there for you when you need them, right?
Totally. Yes.
So
I think people have a general good. They have like an intuition. Hey, am I being oversold? Am I being pitched to? Does this feel slimy? Does this sound good?
Yeah.
Could be true.
Yeah.
Trust your gut. Kind of classic advice.
100%.
All right, let's move on. We've got maybe 20 minutes left, so we've got it. Again, right back to trademark. So we're looking at an abandoned trademark. This one's an oldie but a goodie from 1970s. Let's see if I recognize it. I don't know if they actually cite which one. Okay. There. Oh.
Okay, so I'm reading this here.
You got it?
Yeah. Okay. So I just created my modified version of a trademark on its own. Is there any reason I have to worry about the original trademark being resurrected by somebody and then my trademark being challenged, retroactively infringing somehow?
Right.
Yeah. So this is a question actually. I get this a lot from folks. Usually it's like, people like who have like a childhood brand that they remember that's long since gone out of business and they want to bring it back. You can do that. It's possible. You got to do your due diligence and make sure that the trademark truly was abandoned. It wasn't just transferred to a third party who's still keeping it alive somehow. So you want to look at the USPTO for any registration certificates that are still live and in force. And then see when they were abandoned. That would be important. And then you want to look to see if there's some common law usage out there of this trademark. So is anybody still using it or still selling surplus product of it potentially, right? Is this product still available to purchase somewhere, somehow? And, the owner of the trademark, are they still in business? You'll probably have to do some due diligence there. But, assuming all those things are no, I mean, after I'd say 5 years of non-use, you're probably pretty safe to pick that up, use it.
That's awesome. I queried chat, and you nailed every single part. And then I was like, hey, can you give me some examples of a few old brands that seem to be available?
Yeah.
Pan Am Airlines went out in bankruptcy in 91.
Interesting. I bet so. Pan Am is they're not in business anymore, right? But I bet they still have trademark registrations.
Okay, so right, check with an attorney is bottom line, but some of these are kind of fun. Woolworths. It's a U.S. retail chain. Brim, which was a 1980s decaf coffee brand. I never heard of Brim. Oldsmobile. Now that's a well-known name. GM may still hold residual rights.
Yeah, so like there's always interesting ways that these companies, because there's trademark attorneys to these companies, and they're like, we're not losing the rights to Oldsmobile. Like that's still worth something.
Yeah.
Even they're not in business anymore. So I bet they're making model diecast cars still, right?
Yep.
I bet they're still providing parts for Oldsmobile, right? So the brand's still alive because they're producing.
Oh yeah. If you go to oldsmobile.com, let's see. Oldsmobile.com. I don't know what's going to happen. I mean,
what would they put there? Like a
I don't see anything. Nothing's coming up.
Website or something. I don't know, but they're definitely keeping those brands alive if they can.
I agree. Good stuff. Great answer. All right, let's go back to patents here. We've got a Reddit. Let's see how far along we've got. Maybe, there's like 20 or 30 more. We're doing good though, Matt.
Great.
We've gone through 7 or 8. Okay. Next question. It's loading up. All right. My internet's a little slow. I'm wondering if it's best to assign the patent for the product I developed under my personal name or under my business name. Information on my business. I started the business LLC based around the product I was developing. I've had the business and name for 4 years, and everything has just been in development up to this point, basically stealth mode. I hope to be manufacturing and selling some of the product by the end of this year. That said, would it be best to assign it to my personal name in case I dissolve the business? If I assign it to me, I can also sell the company down the road if it makes more sense for the business. Love to hear people's thoughts on this. Well, and maybe you'll chime in on maybe the business, the branding aspects, but I will say I will almost always advise assigning the patent or IP portfolio to a business.
Correct.
Mainly because of limiting personal liability in all cases. Even if you're still in development and you're hiring, let's say, a new manufacturer or a new designer, you want to engage B2B. Contract business to business. If there's ever a lawsuit, breach of contract allegation, anything where you might be liable, and let's say that designer isn't holding up to their agreement or they're ripping you off and you want to go sue them or they're suing you back, worst case scenario, you lose a lawsuit and now you're liable. Well, by having this shield, right, the corporate veil, you're able to protect your personal liability, having the LLC properly, owning the IP and taking the blow versus you having your personal assets be at risk. So that's why I generally advise signing it to the business. Yep.
That's the right answer, JD.
Very good. Happy with the answer.
Yeah, the only other thing I would say about it is, I mean, yeah, no, I guess we'll leave it there. That was good. Good answer.
ChatGPT agrees. It's generally best to assign the patent to the business for liability protection and clarity and ownership. Simplifies licensing as well. Good point. And enforcement. However, if you're unsure about the company's,
From an optics standpoint, this is really vain, but it looks kind of amateur if you own your IP as an individual as opposed to a corporation or LLC. So just from a future sale of the business, right, acquisition, it's going to feel a little bit more thoughtful or more put together if there's an LLC on file with the USPTO.
Yep. And the last part of that question he asked, let's say the business goes under. Well, you're going to wind up the business to dissolve it, but you're going to, of course, transfer that asset or portfolio back to your personal name when and if the business.
You would never forget to, wind down the business properly and transfer the trademark. You would never forget that.
Yes, that's right. All IP assets.
Always renew your LLC with your Secretary of State on a yearly basis.
This is good. It's good affirmations, Matt. This is
yeah. I mean, that's a big part of my job these days is just like checking clients' LLCs to make sure that, the trademark that we're filing is actually going to be, valid.
Yeah.
Because, I mean, a lot of clients think that they know like their business name, like their LLC or their corporation name. They don't. And so like part of my job is to really like figure it out, make sure like track down the addresses, make sure that the person on the list on the LLC is the individual associated with the actual, client. Because when I was a younger attorney, I'll tell the horror story.
Please.
So I worked for my own firm. I filed a document with the Minnesota Secretary of State for the wrong client. Same name, different, like slightly different spellings. So yeah, that was a waste of a day, basically, fixing that mess. I had to go down to St. Paul, Minnesota, talk to the clerk down there, notify the third party, go over there, have them sign something. Yeah.
Details matter. Details
matter. And mistakes matter.
Yes.
Mistakes have consequences.
That's right. Hello, all. Hello, I've applied for a logo TM, a logo trademark with our business name in it. There's another business name with the same class and a very similar name, I should say. They have one syllable, though admittedly they sound very familiar. That being said, I've gone for the logo TM, not the name. So they've gone for the design versus the word mark.
Yep.
They weren't able to register their name as it was too generic. They also just have a design. Our logos are very different. I have gone with the Head Start program and have pre-approval. I'm not sure what that is. And the reviewer clearly said that she saw no reasons it could not be registered. My question is around objections. How could a business know? Oh man,
yeah, it's like I think it's circular, not this.
And I went circular on it.
Yeah, I was like, am I going crazy? No, I got the question.
Okay, good.
Yeah, so third party with the trademark. I guess what to do about it. So it sounds like in this particular case, this Head Start daycare program has a very descriptive or generic name, like Best Childhood, Head Start program, something like that, right? Neither can register the word mark, but the one has registered the design mark or a logo associated with it. And then this individual's logo is not similar to it, but they probably share a lot of the same words in the logo. So, I mean, in that
particular... Sorry, I think they clarified. My question is around objections. How can a business know that a similar trademark, man, it's really close.
Yeah, how would you know that it's out there?
Yeah, how would you know it was under review objectionable?
Yeah, you're gonna have to look at the USPTO, hire a trademark attorney to do a search. So we can search word marks, we can search design marks really easily now. The search software that we use does translations, but it also does the design mark searches now, and it uses Google search, image search, to also provide some information. So that's where I would start. I would take a look and see if I can find anything similar to my logo, but if it's a descriptive brand and the other parties registered their trademark, they've registered it because they've entered what's called the disclaimer for the words in the trademark. So they're probably getting some graphic elements registered in their trademark, but not the words. And so this individual might have a similar situation.
Yep. Yep. No one notifies them. It's up to them to monitor. It's IP Australia. ChatGPT couldn't pull it together. Their answer is not very good.
Less coherent than mine.
Much less coherent. Thank you, Matt, for being human. Ooh, it's getting hot in here. Let's do one more.
Okay.
I'll go on to trademarks. One more each. Yeah, we'll switch over to patents. We'll wrap up with yours. So two more total. Let's do it. There we go. I had a phone call. This is the UK. Let's see if I can pull the question up. I'm the main inventor on a patent that has just been filed by my university. I'm likely to leave the university in the next 6 months for funding reasons, but plan to keep developing the technology. The university will be the sole owner of the patent. Do I have any free use rights as the inventor, or would I have to pay royalty license on my own work if and when I move on? Both universities are in the UK. Okay. Well, nothing in this life is free, man. No, you did the research, but it's very likely the university maybe paid you for it or provided the resources, equipment to help you do that. University is going to have at very least the rights to it. There's a whole area of IP practice, what's called technology transfer within universities, and there's this whole body of work. I am not all that familiar with it, but I do know that universities are in general more interested in research than they are commercialization. And so tech transfer offices exist just for that, for professors, individuals like you that want to take what's been researched and found out and go move it to the market. So if that's what you want to do, I think you should go talk with what's called the tech transfer office at your university. They'll be the ones that can help you with it. I have a feeling they're going to retain a lot of the rights so they can continue researching and developing, and obviously I'm probably getting financial resources to keep their university going as they do so. But maybe they allow you the ability to sell and to make some perhaps some revenue based on that. Maybe they want to partake or want some bit of that. Any thoughts on that, Matt?
That's my experience working with professors and people in research and development, is that generally speaking, like even though they may not own their invention, right, because it's assigned to the company or the university, generally speaking, these universities are pretty good about letting folks continue their research after they leave the university and commercializing the product. Whether there's some royalty that's paid to the university if it does commercialize, I don't quite know. I know one of my clients, that was the case. They were able to take the research with them, but in exchange, they made a commitment to pay the university X percentage.
Yep.
Commercialization. But yeah, I think you're more likely to get that answer from a university than you are from a business. Business is going to say no.
Yep, business say no. The university is going to say, probably, yeah, go for it. But get it done before you go start selling or making the widget.
Yeah, because a university, at the end of the day, like they're trying to recruit the best researchers to come work for them, right? Yeah. And if you're known in the industry as a hard place to work, or not very kind to your inventors with their rights, people aren't going to want to go there.
I'm not going to want to go there. You nailed it. Yeah,
it's just the free market,
Uh-huh.
The silent hand.
Chat said the same thing. You will not have free use rights, but talk to your tech transfer office to negotiate a license or spin out agreement. Some universities are open to licensing IP back to inventors, especially if you're advancing the work. So get it formalized before leaving to avoid future legal or commercial issues.
Yeah, earlier the better. Have that conversation. I wondered if this individual is thinking of like these free use rights. I wonder if is that kind of like artist rights? Because in the last few years, we've seen a lot more of these like musicians like taking back their work, right? Kind of clawing it back.
Yeah.
Like from a copyright perspective. I wonder if that's kind of what he's referencing here with free use. I've never really heard that term before. Have you?
Yeah. Well, I think there are in the patent world, you can, I believe you can assign it to some entities. I'm blanking on the name of the entity, but that
Like
entity
Collective Commons.
Collective Commons. I think that's exactly it. And
Yeah.
you're getting the patent so that in a defensive way, so that no other big, call them ugly, bad, company, corporation gets to control it. You give it to the world for free. Go you. And you're sharing that knowledge, and it's a free license. But there's still you still own that ability to exclude, IBM or Apple or any of the big behemoth, maybe someone who's classified as a large entity or by the IRS or whatever. So you do get to control who does and who doesn't. And
That's a good point. And like that kind of gets at, one of the things that you kind of taught me a few months back was that one of the reasons that clients or people file patents is defensive. They may have no intention whatsoever bringing this product to market or this method to market, right? But they're going to sure as hell exclude, their competitors from it.
Yep, absolutely. Yep, you can do that.
Cool.
Last question. Last but not least.
And then I'm going to take a nap. I'm tired.
Yeah, this is a lot of work.
And then I'm going to go to the gym.
Works your brain out. Now we got to work your body. So is it worth trademarking my record label name immediately? Or can it wait? And what are the risks?
Yeah. What are the risks? Can it wait? Maybe. Certainly, when it comes to the USPTO and the amount of applications filed, which is insane, by the way, it's like 20,000 a week or something like that. Huge. Relatively few of those are going to be for recording artist services, whether it's production or recording studio services or post-production or whatever, editing services. So, there's a chance that someone's going to file that trademark between now and when you get around to it. But my pushback as a trademark attorney would be like, well, we're talking about you filing this trademark already, which means that you should file it because it's important to you. And if you're going to file it now or in 2 years, you might as well file it now, right? I know it's a little bit more money, but at least then we're doing the right thing the way that it should be done, which is file it early, as opposed to wait and then have to pull it back later.
Yeah, perfect. Matt, we did it. An hour of
All right.
Congrats, man. We did it. Thank you to all out there. We did not get as many live questions as I was hoping for, but if you want to catch us live, we're here next week and every Wednesday at 12 o'clock Pacific, with some summer breaks here and there. So watch our calendar. We will usually have a guest on. If you're watching this after the fact, you can always fire away with questions. I'll take a look at the comments and get those added to our list. But for Matt, myself, and Bold Patents, wishing you guys an awesome week. Go big, go bold.